tenure as DA and covering all counties within your scope, how many indictments and prosecutions have taken place with the death penalty involved? How many death penalty cases have you and your staff won during your tenure?
Okay. I believe during the time that I've been DA, we've announced our intention to seek the death penalty 4 times. 2 of those cases have already been resolved by a plea to life without possibility of parole. The reason for one of those, it was a Fayette County murder. You can't just seek the death penalty on every case. You have to have an aggravating circumstance. They're delineated in the statute just what those are. And in that particular instance, the one that we were relying on was that the murderer had used a weapon in an area that was a danger to the people around. It was in an area where he was endangering other people. As we got closer to trial, it just didn't look like that was going to be a successful effort, and the victim's family was very interested in seeing life without possibility of parole. So that's what we did in that instance. In the other instance where we sought life without, where we agreed to plead to life without possibility of parole, the defendant was mentally retarded. Georgia law won't allow you to execute a mentally retarded person, and we could not come up with the evidence to rebut the presumption that he was retarded based on his IQ.
Thank you. Your time is up. Could you try to limit your response to 1 minute?
The next question is directed to you, District Attorney Ballard, and this is from the audience. Why have you put internet child predators on probation instead of doing time?
That's another instance where you're blazing a new trail. We had a fairly unproven statute that we were trying to operate under, and what our objective was in those cases was to be sure that we could monitor the person and make sure they didn't have a chance to actually hurt a child. See, a child predator on the internet is somebody who has expressed an interest in hurting a child, and you can prosecute a predator without a child actually having to be hurt yet. It was a brand new thing. We didn't know how the parole board would treat people that were convicted of that. We didn't know whether the courts of appeals and the Supreme Court would uphold those statutes. So what we did, we didn't just give probation. We gave detention center and diversion center sentences, followed by long terms of probation with restrictions that said you can't have a computer, you can't have contact with children, you have to register as a sex offender, and things of that nature.
I'd like to get a response from you on that particular issue, Mr. Hayes.
Okay. I'm opposed to probation for internet pornography violators. And I'm especially opposed to first offender probation, which some of these people have gotten. I think that you have got to aggressively protect children. You know, I mean, just today or yesterday, Senator McCain made his intent known that he wants to be more aggressive with child internet pornography. And the whole county needs to, the circuit and the country, everybody needs to be aware that the access that people have to children through the internet is unlimited. You have got to lock these people up. I think it's inappropriate to give them probation. We have got to be aggressive in prosecuting those. One of the first ones that I prosecuted many, many years ago got 15 years in prison. I mean, I just do not believe that it's right to give these people probation, especially first offender probation. Under no circumstances am I willing to say that anybody that is committing an act of child molestation or attempting to commit an act of child molestation on a child is a subject for probation.
I'll take a personal liberty here. This is a little frustrating to me, and I'm not trying to be argumentative or attack you for the press purposes, but you indicated a few minutes ago that you won't take a blanket position on any issue, and you just taken a blanket position on this particular issue. How do you explain that? That sounds kind of a conflict, and we get that a lot of times from our elected officials. They will say one thing one day and another thing another day when another issue comes up. And we're just looking for a little bit of consistency in the way you handle cases.
And I'm telling you, with respect to child molestation and internet pornography, you will have consistency. You know, the question that I responded to earlier, I believe, about not making a broad stroke about the facts of those cases were directed at the people lying on affidavits to get their children into school here. That is something where the background of each one of those families is different. Okay, I know your intent when you're committing internet pornography. Your intent is to have sex or molest a child. And I'm very comfortable, and I don't think it's a conflict at all in that scenario to say that under those circumstances, I am always comfortable recommending prison time.
Thank you.
This question is directed to Mr. Ballard. Why did you recommend a diversion program for the 2 African-American boys who were convicted for gang-related activity? It was their first offense. One of the boys was sentenced to 4 years, and the other boy, who was an honor roll student, was sentenced to 2 years.
Because it offends everything that I believe in, to let this community fall prey to gangs. I have a great love for our school system. I was educated there. My children were educated there. We force our children to go to school. The one thing that they should be able to do when they're at school is to learn. They should be able to learn free from interference by criminals, and particularly free from interference by people who would try to recruit them into a gang. I'm aware of the problem that Clayton County has with gangs. There are 61 gangs in Clayton County, and 43 of those are in their schools. I am not about to tolerate people trying to get involved in gangs and get other people involved in gangs, especially in the school. And I thought that it was a very appropriate sentence, and had they been adults, I would have liked to have seen them get more.
Mr. Hayes, I don't know if you have an opinion on this particular issue. Is that a fair question that you can respond to? This particular issue right here with these 2 kids.
I think I can respond to something relating to that. You know, I don't know, I've never read the file, I don't know the facts, so I'm not going to tell you that that particular sentence was appropriate or inappropriate. What I will tell you is you have to look at consistency. I know one of the kids came forward and testified against the other kids. I've been told that, and he received probation. Contrast that with these 4 juveniles in Peachtree City that were recently arrested, where one kid came forward willing to testify against the other 3, but all 4 got the same sentence. You know, you have to be consistent. If you're going to give these kids a break for testifying against their cohorts, then you got to do it across the board. You got to be consistent with the way you apply your rules. And that's the thing that I see that's happening, is there's inconsistent application of rules that differ depending on who's involved or what the case is. And I think we've got to be more consistent with that.